to you. Just because I do not like to interrupt people talking, I will put up the yellow card when you've got a minute left in your presentation. I do the same thing to the members, so they're getting used to it. And I put up the red card when your time is over. I don't mean for you just to stop in the mid-sentence. Just wrap up what you're saying quite quickly because we're run out of time. All right, that's hopefully will be helpful to you. Who would like to start?
I'm quite happy to do that.
Perfect.
Madam Chair.
Okay, then we'll start with you, Joshua. Thank you very much.
Thank you very much, Madam Chair and committee members, for inviting EcoJustice to provide suggestions to the committee on Bill C-69. EcoJustice is a national environmental law charity providing free legal services to Canadian conservation groups, concerned citizens, and First Nations. Lawyers from EcoJustice appear across the country before courts and tribunals at every level, including with respect to environmental assessment, which will be the focus of my comments today. I'm an EcoJustice litigator and also a part-time professor at the University of Ottawa Faculty of Law and director of EcoJustice Environmental Law Clinic at the faculty, where I teach environmental litigation, including with respect to environmental assessment, and my comments today are informed by those various hats. The points I propose to focus on are the following. First, the discretion to exempt projects from an assessment. Second, the importance of clear requirements for decision-making. Third, environmental justice. Fourth, assessments of federal projects. And finally, review and appeal. I've submitted a brief touching on other aspects of the proposed IAA, as well as the proposed Energy Regulator Act and Navigable Waters Act, which I commend for your review. One of the most consequential effects when the 2012 legislation replaced the previous Environmental Assessment Act was the shift from a triggers-based approach to a project list approach, which limited potential assessments to a short list of major projects under federal jurisdiction. SIA 2012 reduced the number of project assessments to dozens annually, compared to the former legislation that applied to thousands of projects annually. Even then, the 2012 Act added an off-ramp whereby the agency could exempt projects from assessment. That discretion has been used 27 times since the current Act came into force, or about 5 times per year. It is a regular part of agency operations. Here are just 2 examples of exempted projects as a result of that discretion. A gold mine located near Timmins, Ontario, with an ore production capacity of 4,000 tons per day, where the minimum production capacity to trigger a federal assessment is only 600 tons per day, and a crude oil storage facility with capacity for 6.64 million barrels just outside the municipal border of Edmonton, Alberta. The proposed IAA does not remedy this exclusion problem. It retains the discretion to exempt projects from a list that will likely only include those with the most potential for adverse effects in an area of federal jurisdiction, according to the government discussion paper on the subject. Now, to be clear, I'm not suggesting that any particular project ought not to have been approved. But projects make the list because they have real potential for adverse effects, like toxic heavy industry in proximity to communities, like the 2 I mentioned. Failing to assess those projects undermines public trust in the process. Communities should get a full picture of the potential adverse effects of the project and ways the project might be improved. Not assessing such projects also undermines efforts to tackle cumulative effects, which is a core purpose of the bill. We therefore recommend that Section 16 of the Act be amended to allow the agency to exempt a designated project from assessment only if it determines that there is no potential for impacts on areas within federal jurisdiction. In other words, if the presumption of federal jurisdiction that led a project to end up on the list in the first place is rebutted, it doesn't need an assessment. Otherwise, an assessment ought to take place. The lack of clear criteria in the existing legislation has resulted in an interpretation by the courts that decision-making on assessments is based on nearly unfettered discretion. The assessment report is merely one input in an indeterminate sea of considerations that are never made public. The law is so vague that the Federal Court of Appeal concluded that decisions are, quote, based on the widest considerations of policy and public interest assessed on the basis of polycentric, subjective, or indistinct criteria. In other words, After all of the evidence and public participation that goes into an assessment, there's no guarantee that it will do anything to influence the final decision. What's more, courts have doubted whether the law imposes any standards for the content of the assessment report. According to some jurisprudence, it is doubtful whether the report is even required to contain substantive consideration of environmental effects, even serious ones, like the release of liquid effluent from a nuclear reactor into Lake Ontario. The prevailing standard is some consideration, no matter how cursory or disinterested in the relevant evidence that consideration may be. Now, to its credit, the proposed Environmental Assessment Act does try to do more than avoid acute harm. It requires politicians to consider the extent to which a project contributes to sustainability, including environmental, economic, health, and social factors. It also incorporates a consideration of Canada's climate commitments, Indigenous interests, and mandates reasons for environmental approvals. But the IAA should do more than require that factors be considered, since judicial history shows that mere consideration provides no enforceable standard. To avoid the uncertainty as to whether the decision will really be based on the legislative factors, we suggest that Section 63 of the Act be amended to ensure decisions are, quote, based on, rather than simply take into consideration the legislative factors. That would be a significant change in law and accountability in the system, and would help ensure that decisions that are tied to the EA process are evidence-based. While the decision should be based on the Section 63 factors, it's important to note that those factors are incomplete. The section should include bottom lines that place an outside boundary on ministerial or cabinet discretion, so that all participants in an IA understand the minimum expectations. For example, the law should prevent the minister from deciding that adverse effects indicated in an assessment report are in the public interest if the evidence suggests otherwise. The minister should not make a positive public interest determination where adverse effects do not offset some more severe effect, or, as you heard from Professor Stuart-Elge yesterday, unless the benefits substantially outweigh the adverse effects. A project should also not be found in the public interest if evidence suggests it will result in the crossing of a dangerous ecological threshold, or if it will substantially hinder Canada's ability to meet its international, national environmental, climate change, or biodiversity obligations. These bottom lines should not be reduced to optional considerations, which is currently the case with the proposed legislation. Section 63 ought to be amended accordingly. The bill also does not recognize that in Canada, vulnerable populations, including low-income populations, Indigenous communities, and socially marginalized groups, are disproportionately exposed to environmental hazards, while also disproportionately lacking access to environmental benefits. In other words, environmental approvals often lack environmental justice. Let me provide an example from some of our work. In Chemical Valley, located just outside Sarnia, Ontario, sirens can blare at any time of day to warn people to stay indoors when all too frequent pollution incidents occur.
Can I just, I know you're going and you're on a roll. You are going so fast that the interpreters are having a really hard time keeping up with you. You're doing amazing, but
I'm having a hard time.
My apologies. I'm doing my very best to stay within the
I know you're trying to get a lot in a short period of time.
Limit.
I know, and I can't really expend the time limit, but I do need you to sort of just take a breath and slow down because they can't catch up. They can't keep up.
Very good.
Okay.
Thank you. Thank you for that, Madam Chair. So, let me take a step back and provide an example relating to environmental justice from our work. In Chemical Valley, which is located just outside of Sarnia, Ontario, sirens can blare at any time of the day to warn people to stay indoors when all too frequent pollution incidents occur. In 2011, the World Health Organization said that the people of Sarnia breathe some of the most polluted air in all of Canada. The approximately 800 residents of Aamjiwnaang First Nation live next to industrial facilities that account for approximately 40% of Canada's petrochemical industry. We recommend the following to incorporate environmental justice considerations into the IAA. First, definitions of environmental justice and vulnerable populations. Second, a new consideration under Section 22 of the Act relating to whether the area impacted by the project is home to vulnerable populations, and whether the human health or environmental effects of the project, including its cumulative effects may be disproportionately high and adverse with respect to those populations. And finally, a decision-making criterion in Section 63 concerning the extent to which the designated project contributes to environmental justice. Now, the situation in Sarnia also reveals another gap in the IAA, and that is the failure to provide for assessments of projects not only on federal lands, but those with federal proponents or that are federally funded. In December of last year, a chemical company produced a new polyethylene facility in Chemical Valley designed to increase its polyethylene production capacity by 450 kilotons per year. The federal government will contribute $35 million to that project, yet it will receive no federal or provincial environmental assessment. That's an unacceptable oversight. We therefore recommend that Section 81 of the Act be amended to ensure that effects of all federal activities, whether as a proponent or a funder, be assessed. Those assessments should use the expertise of the newly created Impact Assessment Agency, which will ensure that assessments of federal projects are independent and seen to be independent. Finally, I note that the courts are the proper arbiters of when an assessment report is legally compliant and whether the decision conforms to the evidence before the decision maker. And I'll just wrap up. Appeals should be rare, but there should be recourse to them where necessary. I note the discussion yesterday concerning a potential appeal or review tribunal, which we absolutely support. However, if that is impossible at this stage, the IAA should provide for a right to review reports under the Federal Courts Act and to appeal the final decisions on questions of law and jurisdiction. Thank you very much.
Thank you very much, and I appreciate your understanding and patience there wrapping that up. Who'd like to go next? Mr. Namagus.
Madam Chair, Deputy Chair, committee members, bonjour, good day. On behalf of the Cree Nation of USG, I'm glad and thank you for this invitation to address you today with respect to Bill 69. In suggestion the Jintamgat, suggestion the Dukshnat with Gonkan to the Siwa, and suggestion that my name is Bill Namagus. I'm the Executive Director of the Grand Council of the Cree Nation Government. With me today are Cree Nation Government Representatives Brian Craig, Director of Federal Relations, Jeff Quayle, Senior Environmental Advisor, Kelly LeBlanc, Environmental and Social Assessment Coordinator, and Saint-Sebastien, our Legal Counsel. Bill 69 must guarantee the Crees of UC our treaty right under the James Bay Northern Quebec Agreement to be active and mandatory participants in any environmental and social impact assessment of development projects carried out under federal legislation in the JBNQA territory of USG. Any federal legislation providing for environmental and social impact assessment of development projects in the JBNQA territory of USG must ensure that the assessment is conducted by Federal Environmental and Social Impact Review Board, known as COFEX, established under Section 22 of the JBNQA. To achieve these ends, Bill 69 must provide for a carve-out or distinct regime that specifically addresses the JBNQA territory. The Cree Nation of USG counts more than 18,000 Inuit or Cree, occupying our traditional territory of the USG. This territory covers over 400,000 square kilometers and is located mainly to the east and south of James Bay and Hudson Bay. We occupy and intensively use the entire area of the USG, both for our traditional way of hunting, fishing, and trapping, and increasingly for a wide range of modern economic activities. As a result of massive hydroelectric and resource development over the past 40 years, the Cree of the USG have undergone extremely rapid, disruptive cultural, social, and environmental changes. These changes have caused enormous stress on the Crees in terms of our traditional way of life and culture. 50% of Hydro-Quebec power is now generated in our territory. I will now turn to our specific issues which relate to Bill C-69 and the assessment projects of the USG. Section 22 of the JBNQA sets out the first environmental and social impact assessment review regime for development projects in Canada. I want to stress that that was the first environmental and social impact assessment in all of Canada, with a gift from the Cree. This assessment is done by tripartite and bipartite committees that assess both the environmental and social impacts of the projects. One of the main objectives of the regime is to ensure that the Crees are active participants in the orderly development of the resources in the USG, so to safeguard their hunting, fishing, and trapping rights are detailed in Section 24 of the treaty. There are 4 joint committees established under Section 22 of the JBNQA. For today's purposes, the relevant committees are A, the Federal Environmental and Social Impact Review Panel, also known as COFEX, a joint Cree Canada panel which is mandated to review projects under federal jurisdiction. The COFEX is composed of 5 members, 3 appointed by the federal government and 2 by the Cree Nation government. B, the Provincial Environmental and Social Impact Review Committee, also known as COMEX, a joint Cree-Quebec panel which is mandated to review projects submitted to provincial legislation, subject to provincial legislation. The COMEX is composed of 5 members, 3 appointed by Quebec and 2 appointed by the Cree Nation government. Over the years, the Crees have been involved in litigation regarding Section 22 and the various federal assessment processes external to the JBNQA, including the Environmental Assessment and Review Process, or ERP guidelines, and the Canadian Environmental Assessment Act of 1982, known as SEA. The most recent litigation on these issues ended up with a 2010 decision of the Supreme Court of Canada in Quebec versus Moses. The Moses judgment distinguishes between environmental review processes internal to the JBNQA treaty and the environmental review processes external to the treaty as required by SEA. The court held that the JBNQA treaty permits only internal reviews process, either federal, provincial, or combined. However, an external federal review process is also required where mandated by the federal environmental law. The federal assessment process external to the JBNQA proved problematic in the past as they set out a regime in the JBNQA territory that did not take proper account of the specific context of the JBNQA treaty, a fact expressly noted in Supreme Court of Canada in Moses. In addition, the federal assessment processes were set out despite the treaty requirements that the federal laws or regulations be established by and in accordance with Section 22, including the Cree right to be active participants in the decisions made for the territory. The key message for our submission today is that Bill C-69 should provide for a carve-out for the distinct regime to address specifically the JBNQA territory. In so doing, Bill C-39 must guarantee the Cree rights of the USG, our treaty right under the JBNQA, as recognized in Moses' decision, to be active and mandatory participants in the assessment of development projects in the USG carried out under federal legislation. The mechanism to ensure this participation is the COFEX panel, already established under Section 22 of the JBNQA. The Crees have consistently urged our federal counterparts to use COFEX established by the JBNQA to assess all projects subject to external federal review processes in the JBNQA territory and not to impose foreign process. In Moses, the Supreme Court accepted the Cree arguments in respect to the necessity to ensure Cree participation in external federal environmental assessment of projects in a manner compatible with JBNQA process. The following sentence of paragraph 48 of the judgment sums up this view of the Supreme Court. And I quote, "Common sense as well as legal requirements suggest that SEA assessment will be structured to accommodate the special context of a project proposal in the James Bay Treaty territory, including the participation of the Cree." This statement indicates that a project subject to internal assessment by COMEX under JBNQA should not be reviewed by COFEX when an external assessment process is required under the federal legislation. We have been in discussions with Canada since 2010, including through the dispute resolution process, further to a passing of section of SEA of 2012 in an attempt to ensure that changes called for in the Moses judgment are properly implemented. So what is the solution for the JBNQA territory? The solution is simple and anchored in 2 basic principles flowing from the JBNQA treaty and the Moses decision. A, every time an internal assessment is carried out by COMEX under JBNQA territory for a project that impacts within areas of federal jurisdiction or that requires a federal permit, an environmental assessment should be carried out under the proposed Impact Assessment Act. And B, impact assessment under the proposed Impact Assessment Act in JBNQA Cree territory should be conducted through COFEX, already established under Section 22 of JBNQA, thus ensuring direct Cree participation as mandated by the Moses Supreme Court decision. In order to ensure certainty and predictability, we urge Canada to engage with us immediately in discussions to make the necessary amendments to Bill C-69 and Section 22 of JBNQA to put in place the various agreements and regulations required to give effect to the proposals that I have outlined here. On the Canada Energy Regulator Act, the most pressing amendment required of the Canada Energy Regulator Act is to clarify that the consent of the concerned Cree First Nations is required when a company proposes to construct a pipeline on Category 1A lands where our communities are located. If a company proposes to engage in related activities or take possession of such land, this requirement requires an amendment to Section 317 of the proposed Canada Regulatory Act. In conclusion, Bill C-69 proposes a measure of consultation and accommodation with respect to First Nations. However, the JBNQA, as affirmed by the Supreme Court in Canada in the Moses judgment, goes further by providing the Crees with a treated right to full and mandatory participation in environmental and social impact assessments and reviews carried out in JBNQA territory. We are available to answer any questions. Thank you.
Thank you very much. Really appreciate that. And up next? Who's up next? Jamie?
Good afternoon, and thank you for the opportunity to be with you today. I would like to begin by acknowledging that we are on the unceded territory of the Algonquin Nation. This fact needs to shape our discussions here. It is not just something we say before we go about our business, but a reality that we need to carry through everything that we do. Like many, Mining Watch was greatly encouraged by the government's commitment to reforming environmental assessment, as well as the expert panel process that was created to advance that agenda, notwithstanding its compressed time frame, both in the astonishing extent and thoughtfulness of participation from the public, Indigenous people, and experts alike, and in the depth of consideration that the expert panel reflected in its report. My focus today is primarily on Part 1 of Bill C-69, the Impact Assessment Act. There are certainly important concerns with respect to other parts of the bill, as well as Bill C-68, the Amended Fisheries Act, both on their own and in relation to the Impact Assessment Act, especially regarding the assessment and monitoring of non-designated projects. I would direct your attention to the submission of the Canadian Freshwater Alliance, especially as it appears they will not be called as a witness. This bill brings great promise and great disappointment. Overall, we find that it cannot fulfill the government's commitment to restore public confidence, and therefore also cannot fulfill the promise of facilitating good development projects. In some respects, it represents a failure of ambition, where a stronger commitment and stronger leadership are required to meet the challenges of the 21st century. In other respects, it's just a matter of design flaws and limitations of implementation. At this juncture, it may not be possible to address the bigger structural problems, but we have the opportunity to fix many of its deficiencies. We are greatly concerned that while this committee has heard the testimony of the responsible ministers, it has not heard from the civil servants, the government's own experts, who worked diligently to develop the government's direction into the bill before us now. We strongly urge you to call those involved in drafting this legislation as witnesses. We are also greatly concerned that there is very little time for this committee to hear witnesses and to develop and integrate the necessary amendments in order to allow for a more thorough evaluation of some of the critical structural aspects of the Impact Assessment Act. The Minister, through the new Impact Assessment Agency, should undertake a short-term review of the new Act and develop a package of housekeeping and substantive amendments to bring before Parliament within a year or two. As well, the proposed 10-year parliamentary review will come much too late. The legislative review requirement should be changed to a 5-year ministerial review cycle. I will not attempt to address the needed amendments comprehensively. There just isn't enough time. But we have worked extensively through the Canadian Environmental Network, the RCEN, and the Environmental Planning Assessment Caucus, of which Anna and I are both co-chairs on a national level, that have made submissions to this committee. We endorse and support the observations and recommendations of the caucus as well as those of its other members. And I would refer you to the caucus written submission, as we're not actually here on behalf of the caucus. The bill does make an important advance in setting out a broad consideration of economic and social factors in addition to biophysical environmental impacts. All of those factors are to be subject to public scrutiny and scientific evaluation, allowing decisions to be based on much more transparent reasons and justifications than has previously been the case. This is something we have advocated as critical to allowing an assessment of any proposal's contribution to long-term sustainability. The bill's inclusion of gender-based analysis is also important. However, and I think as Josh has already laid out, the bill does not provide a clear legal link between the consideration of those factors and the justification for actual assessment decisions. Neither does it establish basic criteria to provide a solid and consistent base for those decisions. As Professor Doyle has pointed out in his submission, the enabling nature of the legislation allows for good decision-making to take place, but it does not guarantee it, and without clearer requirements for justification, doesn't even encourage it. Provisions that enable action also enable inaction and do not provide certainty. It is greatly helpful in understanding the application of discretion if, wherever the bill says the minister may, one reads the minister may not. This is not a question of ill will or irresponsibility, but more one of natural administrative tendencies to conserve money and energy and natural political tendencies to seek short-term benefits. We note that the question of discretion has been raised as a concern of all sectors, including industry representatives, Indigenous peoples, public interest groups, and environmental law experts, with varying degrees of emphasis on, I think, three factors. First, certainty and clarity, being able to know what the decision-making criteria are at the legislative level and how they will be established at the level of individual project assessments or regional and strategic assessments. Second, fail-safe criteria, assurance that where benefits, or at least no harm, cannot be assured in all areas, any trade-offs will be subject to defined weighting and limits. And third, Indigenous self-determination, definitive protection for Indigenous rights, including implementation of the UN Declaration on the Rights of Indigenous Peoples, so that impacts on treaty and Indigenous rights and the outcomes of nation-to-nation processes are determinative, and so that the requirements are clear and knowable. And I think the James Bay and Quebec Agreement, Northern Quebec Agreement, provides a clear example of that. We urge the committee to pursue amendments to more closely tie the Section 63 decision-making factors to Section 22's factors to include in an assessment. This is not the first time you're hearing this, and it won't be the last. But we should include a requirement for regulations setting out generic decision-making criteria in each area and establishing a requirement for specific criteria for individual assessments, as well as making impacts on treaty and Indigenous rights and the outcomes of nation-to-nation processes determinative and not just considerations. We have made recommendations for specific amendments and provided background arguments in our written submission in 7 other areas to help ensure that public participation is meaningful, that Indigenous peoples' involvement in assessment processes respects their self-determination, that there are effective mechanisms to assess regional development impacts, as well as policies, plans, and programs with clear links to project assessments, that impact assessment is linked to monitoring of non-designated projects authorized under the Fisheries Act and the Navigable Waters Act, especially in relation to cumulative effects and project assessments, that energy regulators have a specific and much more limited role in assessment processes, that international transboundary processes and international obligations and guidelines are given adequate weight, and that scientific integrity is built in, including in mitigation, adaptive management, and follow-up. In conclusion, Bill C-69 has the potential to make important and badly needed changes in the federal impact assessment regime. Unfortunately, it does not provide clear enough direction on implementation to give us confidence that its promises will be fulfilled. It also replicates many features of the existing failed SIA including its limited scope of application. We have provided recommendations in key areas, and we trust this committee to do its best work to improve the bill. Thank you.
Thank you very much. And we'll hear from one more, Ms. Johnston.
Thank you very much for this opportunity to be here on the traditional territory of the Algonquin Nation. My name is Anna Johnston. I'm a staff lawyer with West Coast Environmental Law, a nonprofit environmental organization that's been protecting BC's environment through law for over 40 years. Today I'm going to focus my comments on the Impact Assessment Act. I will make a couple of recommendations touching on the Navigable Waters Act amendments and the CERA, but mostly focusing on the Impact Assessment Act. I won't be able to go into nearly as much detail as we did in our brief, of course, but I will suggest that if you want more specific language, we've put a series of actual amendments in our appendix. So the Impact Assessment Act intends to introduce some important and much needed shifts in the way that we do environmental assessment here in Canada, but we're concerned that the Act leaves a lot of detail and to guidance and to the discretion of decision makers, and so fails to provide the kind of certainty that we need that assessments on the ground will actually achieve the Act's goals, or that future governments will implement the Act as it's intended. So my first set of recommendations is around how to make the planning phase work. We welcome the introduction of a planning phase, which we believe can help improve public engagement, collaboration, and the conduct of assessment. But the combination of the agency decision, as Josh mentioned, about whether an assessment is required at all, and the lack of any requirement for there to be clear outcomes of the planning phase, risks that this phase will just end up becoming a screening level assessment. So in order to make it function as it should, we recommend two things. One, as Josh suggested, limiting that agency determination to only a determination that no assessment is required where there's no federal jurisdiction, so get rid of that discretionary ability to exempt projects. And then second, turn Section 16.2 into a requirement that the agency produce an assessment plan that prescribes the things that need to be considered in the assessment, the way the participation opportunities have to be considered, criteria to guide this decision, and timelines, etc. Secondly, to ensure sustainability, we have a series of recommendations. We fully support the transition towards the broader impact assessment model and the purpose of the Impact Assessment Act to foster sustainability, but we're really concerned that ultimately decisions don't have to actually help achieve sustainability or help Canada achieve its climate commitments. So as both Josh and Jamie suggested, we fully support that Section 63 be amended to require that decisions be based on those factors that are listed, and instead of just take into account those factors, so that decision makers can't, for example, take into account whose riding the project is in and votes that count. Also adding some legal bottom lines, we completely support that to make sure that there are certain circumstances where projects cannot be approved. For example, when there's a significant risk that they'll hinder Canada's ability to achieve its climate commitments. And then thirdly, tightening up that decision statement, Section 65, so that instead of just issuing a decision statement, which in my reading of it, a decision maker could just say, I've considered all the factors and believe that the project is in the public interest, actually requiring decision makers to explicitly justify how they've reached the public interest determination and any adverse effects, residual adverse effects. I've represented clients on an environmental assessment where they picked up cans out of ditches for years and held bake sales and dances to fund their participation in a project where the review panel report was essentially ignored by decision makers. It made a mockery of the process and was a complete pointless exercise of years of my client's life. In order for them to feel like they've been meaningfully concerned, been meaningfully heard, they need to be able to see that justification that went into the decision. The third area I'm going to touch on is how to achieve binding regional and strategic assessments. So the committee, I think, already has heard quite a lot on how to ensure that regional and strategic assessment tools are used and used well. In addition to those, we'd recommend, first of all, enabling the minister explicitly to enact regulations prescribing how those assessments are conducted so that we know that they're done in a robust and rigorous manner, and also to prescribe periodic updates to them so that that information doesn't become quickly out of date. Secondly, amend the Act to require that those strategic and regional assessment outcomes actually are binding on project level decisions instead of just factors to consider, because otherwise, if it's all left to discretion, there, isn't necessarily much of a point in doing them. And then finally, related to that, we'd recommend actually requiring a government, so either ministerial or cabinet, decision at the end of a regional or strategic assessment. This can be done in the form of a response to the committee or agency report, and it can say whether or not it accepts the report, accepts it with modifications, or rejects it. But in order for regional and strategic assessments to provide that necessary policy guidance at the project level, we believe there has to be some kind of a government decision at the end of them. So I'll next turn to how to ensure that participation is actually meaningful in assessment. There's a good intention in the Act to meaningfully engage the public. We were quite happy to see that there's no more standing test, but we're again worried that the lack of specificity in the Act means that assessments don't necessarily need to provide those meaningful opportunities. So I just want to make clear that the goal here isn't to get 100% agreement on decisions, but it ought to be and can be 100% buy-in of them. So to that end, our earlier recommendation that the agency be required to produce an assessment plan, I think will go a long way to helping get buy-in by setting out a participation plan that the public has actually been consulted on in that planning phase. In addition to that, we'd recommend just amending, it's a pretty simple amendment to those public participation processes to say that public participation should be meaningful and in accordance with that assessment plan, and then amending those timeline provisions to allow the agency to come up with alternate timelines in that planning phase. So a little bit of flexibility to adapt the length of assessment processes as required. And then finally, I'll touch a little bit on the federal projects, getting the federal house in order. So the provisions respecting federal proponent projects on federal lands and projects outside of Canada were quite disappointing. To better ensure that the federal government's own project actually help achieve sustainability, we'd recommend, as Josh pointed out, including as a trigger for those projects that have federal funding or where there's a federal proponent on provincial crown land or private land. Also appointing the agency as the responsible authority rather than letting federal proponents self-assess themselves. Third, bolstering the public participation opportunities. That currently just says that the federal authority should make a determination and provide a 15-day comment period before that determination is made. So they've already made the decision. They're not even doing an assessment there. So lengthening those public participation processes, requiring the federal proponents to provide project descriptions is a pretty basic amendment that should be a given in any assessment, and then having a comment period on the draft determination. So we did, in our brief, we made recommendations on a few other areas, including, really importantly, respecting how to uphold Indigenous rights and jurisdiction and decision-making authority. Given that this committee is hearing from a number of Indigenous colleagues, I think I'll defer to their submissions on that front. And I will just quickly turn to a few recommendations respecting the Canadian Energy Regulator Act and the Canadian Navigable Waters Act, as I think it'll now be named. So we didn't provide a brief on the CERA. We support the recommendations that a number of our colleagues, including the Pembina Institute, Environmental Defence, and Équiterre, provided. In particular, we would like to support amendments that would align the CERA with the Impact Assessment Act in requiring that reviews of energy transmission projects consider climate implications and align with Canada's climate targets. In addition to those submissions, we do have one additional thing that we'd like to bring to your attention. We'd recommend amending sections 201 and 202 of the CERA to allow non-landowners to submit comments on detailed routes and to participate in hearings on detailed routes. So right now those provisions are just limited to landowners, but there of course are going to be circumstances where landowners are not aware of sensitive ecosystems, stream crossings, or where pipelines will cross on provincial crown land. So just to make sure that we're actually routing pipelines and transmission lines where they ought to go, include general public provisions in those. And then finally, on the Navigable Waters Act, we did submit a brief on that. I just want to make two really quick comments. One recommendation would be to amend Section 7, Sub 7 to add environmental considerations to the factors that have to be considered when assessing projects under that Act. We've been told that the amendments to the Navigable Waters Act are supposed to act in conjunction with the Impact Assessment Act, and that the Navigable Waters Act is supposed to catch projects that aren't being caught. If you're not considering environmental factors under the NWA or NPA, then it's not a safety net. And then second, either delete either delete the definition of navigable waters or amend it. Right now, it takes a much more restrictive definition than what a lot of the common law cases say. So either delete it or apply the broader common law definition of navigable waters to make sure that we're capturing them all. Thank you very much.
Thank you very much. Thanks to each of you for your very detailed advice and recommendations. And we'll open the floor to questioning. We'll start with Mr. Amos.
Thank you, Madam Chair. Thank you to our witnesses. Really appreciate the effort and consideration that you've invested in these presentations and also in your written submissions. We will be reviewing all of it closely. I wanted to explore, and it's in fact it's Mr. Namagoos's comments that have caused me to turn my mind to the issue of substitution and equivalency around federal and provincial assessments. But my question is actually not directed towards Mr. Namagoos because he's sort of raised the issue for me, but I want to address my questions to Mr. Ginsberg, Mr. Neen, and Mrs. Johnston. What is your assessment of the current framing of these provisions? And what are the strengths and weaknesses that you see? In my estimation, this is one of the most crucial aspects of this legislation, but all too often not enough attention is paid to how we're going to make this law work in a context of federalism. So if you could please expand on that, I'd appreciate it.
Yeah, I'd be happy to. Thanks for that. We really believe that the ultimate goal of the intention of one project, one review should be multi-jurisdictional collaboration, not substitution, and that where any kind of collaboration or substitution is allowed, that should be to the highest standards. So we were fairly disappointed in those provisions in the Act, and we think that if the government wants to move forward with retaining substitution as an option, that it needs to, first of all, require any substituted processes to actually implement those or to fulfill the conditions that are set out in Section 63, rather than just be based on the minister's opinion that they will live up to some general standard. Add a requirement to obtain Indigenous consent on substitution decisions, and then require participant funding in substituted processes. So right now the Act exempts the federal participant funding program from substituted processes, but a lot of provincial jurisdictions, including mine, don't provide participant funding. So that should be maintained.
Sure. I think what the drafters have tried to do is cover too much ground with one concept, and they've tried to accommodate substitution of provincial processes and recognition of Indigenous processes in the same basket, and it's not working because there's a set of requirements that I think we'd be quite cheerful to apply to provincial processes, that they have to meet the standards that Anna was talking about. But provincial jurisdiction over natural resources is not the same thing as Indigenous self-determination and constitutionally protected agreements like the JBNQA and all of the modern comprehensive claims. In addition to recognition of treaty rights. So if you're talking about nation-to-nation relationships, I think that is not the same thing as federal-provincial relationships, and they don't work well together. So I've proposed elsewhere that these actually be treated separately, that there be that specific recognition of the nation-to-nation relationship in law, not just in rhetoric, and then that the provincial jurisdiction be treated in this in a more collaborative way. So there is provincial jurisdiction. We have had harmonized and I think successful environmental assessment processes, and we can work on expanding that to sustainability assessment or impact assessment. But and of course there's lots of room for other cooperation, other collaborative processes, whether that's regional municipalities, whether that's provinces, doesn't really matter.
I would just add one brief point, which is that if it is proposed to substitute the federal process with something new that may be less familiar to participants, there should be an opportunity to comment on the form that assessment will take, which would involve a description of the method of substitution to be posted on the website created by the Act, and an appropriate opportunity of time for the public to comment on that and potentially adjust it to reflect the needs of the particular assessment.
1 minute. I'd like to ask your quick comment on the merits of the Impact Assessment Agency as a dispute resolution entity versus a separate tribunal, such as one that was discussed yesterday.
Yeah. Well, I don't think the agency could really fulfill that function because it's going to be at the heart of a lot of the disputes, right? You don't want the responsible authority providing alternative dispute resolution, mediating, for example, disputes that are between it and the public or it and other jurisdictions. So I think that having a tribunal take over those functions is a terrific idea.
Yeah, if we're talking about a review after the fact of a report or a decision, clearly the agency itself is a bit too embedded in the initial determination, I think, to be impartial enough. But if we're talking about something like mediation that existed under CA 92, then potentially there's a role there.
That's it. Sorry, Will. Mr. Sopak.
Thank you. One thing, I was disappointed in the testimony of the witness. I didn't hear any enthusiasm for economic development and the human capital that is elevated because of economic development. Both Mr. Ginsburg and Mr. Neen, both of you I could tell you were opposed to the changes we made in CIA 2012. That's a fair assessment. Mr. Ginsburg, I'll ask you directly, which environmental indicator quantified in Canada declined because of the changes we made in CIA 2012? And I'm asking for a number regarding a science-based evaluation of the environment. Which environmental indicator declined?
Well, one thing that certainly does spring to mind is that we are not, and this has been confirmed recently by the Commissioner of the Environment, we are not making sufficient progress towards meeting our international climate goals.
CIA 2012.
And well, it certainly does.
Is it? Can you prove that?
Environmental assessment plays a very crucial role in understanding and ensuring that projects, in fact, help to achieve our climate goals rather than derogate from them. So far, it's fairly clear that we are not on track to meet those goals. An act that explicitly contemplates climate and makes it a bottom line should go a long way towards improving that particular indicator.
So I didn't hear a number, which is fine. And I expected that because when I was on the Fisheries Committee, I asked witnesses who were against the changes we made to the Fisheries Act exactly the same thing, and not one person could point to any environmental indicator. I'm a strange kind of guy. I actually look at the environment, look at the numbers for the environment, and I hear none of that, unfortunately. And it's quite obvious that what is proposed here is a kind of throttling of Canada's natural resources industries, and by extension the economy. And I should point out, the Royal Bank has pointed out, there's a real outflow of capital from this country, and quote unquote, investment by foreigners has collapsed. Foreign direct investment in Canada clocked in at $31.5 billion in 2017, down 56% since 2013, when it totaled $71.5 billion. And again, the wreckage of communities that results from that is only beginning to be felt. Chris Bloomer, the head of the Canadian Energy Pipeline Association, actually pointed out that Canada has a toxic regulatory environment, and our competitiveness has slipped to number 16 out of 17 countries, and we used to be in 8th place. So By the looks of it, I don't think we're going to have to worry about too much economic development, especially in the resources sector, over the next little while. Mr. Ginsburg, you were quite negative about ministerial discretion. What is it about having, and this is quite common in groups like yours, why is it so offensive to have people who are elected by citizens have the ultimate decision-making authority in the public interest?
The problem with excessive discretion is the uncertainty that it creates. If you go into a process without understanding the benchmarks by which you're going to be judged, neither industry who wants to get a project built nor other participants can have any confidence that the outcome will reflect their concerns or indeed will contribute to sustainability, which is the purpose of the Act. Bottom lines help to level that playing field.
Yeah, but that is what we politicians do. We have our ear to the ground all the time, listening to what the public is saying, and we have to factor in every situation before a decision is made. And at least when an elected official decides something, citizens have a recourse. When an unelected body, and none of you are elected with the exception of Mr. Namagoose, I presume, when unelected bodies make final decisions, where do the citizens go? They can't go anywhere. We had a very interesting testimony on this week from Chief Ernie Cray of the Cheam First Nation in BC, and he was quite blunt in what environmentalists have done. The headline of the article reads, "Environmentalists red-wash their fight against pipeline," First Nation chief says, and I'm quoting him. This isn't me saying it. We have a vigorous, quote, "We have a vigorous environmental movement in BC, and they have learned that they can use Aboriginal communities to advance their agenda." We also had testimony from Chief Boucher from the Fort McKay First Nation, an area that I'm familiar with because I spent time in the oil sands myself. They have 100% employment in their community. The annual income was $120,000 per year, and they have financial holdings in excess of $2 billion, thanks to their willingness to do business with oil companies in the oil sands. Mr. Neen, is this a bad thing to have 100% employment?
Of course not.
That very big question.
No, full employment is a great thing. I think the obstacle that we're wrestling with is the lack of consistency in decision making and the inability, without criteria in front of us, to understand what the implications are of those decisions. That's the point of trying to put economic development in the context of a sustainability assessment, is to be able to actually interrogate all of those claims, understand the direct and the indirect effects of any proposal, and evaluate them as such and not in a black box behind some political
Communities with
confidence.
100% employment are
Thank
happy
you very
communities.
much. We're out of time on that questioning, but we obviously will have another chance to pick it up. Ms. Duncan.
Thank you, Madam Chair. Rather than propounding, I'm looking forward to hearing more from you. Great testimony, great briefs. I wish we could have more time with you, and I want to thank Mr. Neen for the recommendation that if they sign off on this really fast, let's have another review quick to solve the problems. My first question is to you, Mr. Namagoose. Very interesting. Now, I notice that there is what one might call a carve-out in Section 40 of the bill for the Mackenzie Valley Resource Management Act. And the bill doesn't seem to recognize there's a difference between those First Nations who are under historic treaties and those First Nations who are under modern treaties, First Nation final agreements. And of course, the Cree and Quebec have been very innovative in the agreements that you've managed to reach. So that's one area that probably needs to have a look. Why are we only singling out Mackenzie Valley Resource Management for that? It raises the question with me about Nunavut and Yukon and so forth. When you, Mr. Namagoose, propose, are you proposing that, first of all, are you proposing this mechanism only when the projects are on your lands, or are you proposing if your lands and peoples are also impacted? My second question is, are you proposing a joint panel where the Cree would determine who your representatives are? And third, are you proposing then it then be under the auspices of your, what do you call it, the J, your agreement. So I'd appreciate a little bit more clarity so we can make some sound recommendations for the Act.
The JBNQA is the James Bay Northern Quebec Agreement, signed by Canada and Quebec in 1975. It's actually signed by the Liberal government of 1975. And it's a treaty, and it's protected by the Canadian Constitution. It's part of the law, and it was the first environmental and social impact assessment of its kind in Canada. So that's like I said, it was a gift of Cree to Canada. So there is, it has legal status, and there is already a process in there, and that we would want that process to be respected. And the main thing is that the Crees participate in the review process, and it's a social impact review process also. And the JBNQA is that was the deal for getting the approval and the construction of the project of the century in 1975. We accommodated that project of the century in 1975. And these are, the Section 22 has already assessed and approved and recommended and amended huge projects already in the territory. So it's a successful process when the Crees are participants. Rather than being outsiders and making complaints, we are participants of the process.
Can I just suggest that what you've raised here I think is very important, and if there's anything that you can further submit to our committee to outline how you think that might go about. For example, I would think you don't just want an Indigenous person appointed to a panel, you want to have representatives of the Northern Cree selected by the Northern Cree. So any details you could provide I think would be really helpful. My other question is to the other three on the panel, and that is simply, what do you believe are the most critical changes needed to the bill to restore public trust in the federal assessment process? In addition to what you said, or what do you think needs to be done?
Well, in addition to my point about clarifying the decision criteria in Section 63, the bottom lines I discussed, which is absolutely critical, I would also underline something I didn't get a chance to mention, which is the importance and the central role played by regional and strategic assessments. There's a huge amount of promise in this Act that for the first time we may get regional assessments that look at landscape issues and strategic assessments that consider policy issues in a way that can provide guidance to project-level assessments, and so they don't get bogged down with those issues. The problem or the gap is that it is not clear from the language of the Act that those assessments will actually proceed, because once again they are left to discretion. A helpful amendment would be to have the expert committee that is contemplated under the Act recommend a list of regional and strategic assessments that ought to occur, and to have the minister respond to that, and even better, to potentially schedule those regional and strategic assessments in the Act such that they stay on the radar and don't fall off it if, for instance, there's a change of government. That's a critical piece.
I suppose I can't say everything.
Sure you can.
Because it's a package. Yeah, I think I'd go back to two things. One would be that planning phase, and reflecting on what Mr. Sopak said about the regulatory environment right now being fraught. I think one of the intentions of SIA 2012 was to shut the public out of environmental decision making, and so we're in this boat now where we have protests and we have lawsuits because the public don't feel like they have a forum in which to meaningfully engage and have their concerns heard. And so the more you can actually do in that assessment planning phase, the more you can get the relevant jurisdictions, Indigenous peoples, the public to sit around the table together and design the process to ensure that all the right things are being considered, and the participation occurs in a meaningful way and collaboration agreements are entered into, I think the more easily you get to decisions that work for everybody.
Thank you very much. Next up is Mr. Boss.
Thank you, Chair. I wanted to expand a little bit on where Mr. Amos left off. I assume you're familiar with Ontario's Environmental Review Tribunal process. that is used as an appeal process. And I wanted to know if you felt that we should be establishing a statutory right of appeal that lies from ministerial or cabinet decisions on designated projects to a specialized independent body established under the Act on the model of Ontario's Environmental Review Tribunal. Would you concur with that? And I guess in saying that, are there any other suggestions that you would recommend under Section 63 to ensure that we are fully involved in protecting the public interest?
Yes, I'm happy to address that. As I suggested in my submissions, the idea of a dedicated review tribunal to, in first instance, review final decisions made under Section 65 of the Act is a good idea, in my view. Certainly, courts are the default body and can turn their minds to these issues, but to have a body that is both independent and has some expertise in environmental assessments could be potentially helpful. As to the model of Ontario's Environmental Review Tribunal, I think it's potentially helpful. I would mention, though, that the issue of access to the tribunal in terms of a leave test is a barrier that ought not to be replicated if we are going to do that federally.
Okay, Anna, would you like to?
Yeah, I think it's a great idea, as I said before. I'd add two functions of this body if it is implemented. One would be to provide alternative dispute resolution on multi-jurisdictional negotiations, government-to-government negotiations, all the way through. So in the planning phase, for example, if jurisdictions can't agree on a conduct of assessment agreement, this tribunal could either provide mediation or arbitration at their agreement to get us to a process that everybody agrees on. And then second, equipping it to undertake quality assurance programs, both of project-level follow-up programs, but then also of the implementation of the Act in general. I think one of the witnesses yesterday was talking about how a quality assurance program would greatly contribute to the learning in environmental assessments in general, and so having some kind of an independent oversight body to do that, I think would really help us to actually begin to learn from.
What other public interest aspects would you add to Section 63?
So, as trade-off, as public interest.
Well, perhaps I'll just underline the environmental justice aspect, which is an important consideration to, again, on the theme of leveling the playing field, taking into account that environmental impacts don't actually impact everybody the same way. And if Section 63 was sensitive to that, that would be a significant improvement to the bill.
Anything else like that, Jamie or Anna?
Yeah, so we've recommended adding any criteria that are set out in regulations to help guide the decision. And then, yeah, that's it. But so allowing the minister to enact regulations that would help provide that kind of guidance in a more detailed way that we can't get in the legislation. And then any criteria that are developed in the assessment plan that I mentioned in 16.2 that could be tailored to the specific needs of the project.
Okay, and Jamie, if you're interested, quickly.
Yeah, just one quick additional point. This is a good place to link to regional and strategic assessments to say that the results or the output of those kinds of assessment, that's where you take them into consideration and they become part of the decision.
Okay. Under the Bill C-68, the Fisheries Act, there's a description in there of the relationship with Indigenous communities under that Act. Would you, are you familiar with that section of the Act on C-68? Okay, so maybe the question isn't going to be Chief Bill Namagus, are you familiar with that section of the Fisheries Act on C-68? Okay, I would just say that it's actually, to me, is a very good description of how the relationship should happen with Indigenous peoples under C-69, and would like to see that actually taken from C-68 and brought over to C-69. I don't know why it wasn't done in the first place, but anyway, I'll leave that there. Meaningful public participation, I know we've already spoken a bit about that, but I'd like to get your feedback as far as, in the early planning phase of public participation and looking at meaningful public participation, but also alternatives and need. Can you talk to that as far as how did you define it, and how would you actually ensure that the right criteria is in place to establish, to make it happen?
So really briefly, I would say public participation is meaningful when it has the opportunity, a real opportunity, to impact both the conduct of the assessment and the final decision. One thing I'll draw the committee's attention to is the scoping decision. In Section 22 is right now left to the discretion of the minister. Effective public participation would influence that decision.
Nana?
Yeah, so I think that to be meaningful, processes also have to be deliberative and engaging the public in that planning phase on how they want to be engaged. You know, what are the seasons in which they may not be around because they're out on the land, or you know, do they want formal hearings where they're lawyered up, or do they want to sit around round tables? So really engaging them early on in that process. And then also, as you mentioned, on the alternatives to the project, do you want a road to get to that mine, or do you want fly-in? What works best for the communities?
Okay, thank you very much, Mr. Sopak. And this will be our last question for this panel.
Anyway, I want to continue on with the human aspect of the resource development and communities. Chief Cray was a incredible witness. What a forward-thinking leader for his community. He spoke at great length about how the young people in his community were so looking forward to the Trans Mountain Pipeline, eagerly awaiting the training that would occur because of that pipeline going forward, and so on. He also expressed some great concern over the lack of foreign investment in Canada. He had a deep understanding of the Canadian economy and the interactions with his community, with the larger economy, and the need for foreign direct investment. Ms. Johnston, do you think Mr. Cray Chief Cray is misplaced in his concern for his community and the absolute requirement for the Trans Mountain Pipeline to go through from his perspective? He was looking at some $300 million worth of mutual benefit agreements, and that's all at risk now. Is that a good thing that that's at risk? Ms. Johnston.
Yeah. Well, I think the real misfortune with Trans Mountain is that it was assessed under a process that was intended to shut people out. As I mentioned earlier, the reason why we're in this situation now is because Indigenous peoples and concerned members of the public, communities whose lands and over whose waters the project would be built, were deliberately excluded from the assessment, or when they were able to participate, were able to have a meaningful say. And so this project was attempted to be rammed down the public's throats, as opposed to if all of the parties had been brought around a table in a deliberative manner at the very beginning. Either maybe everybody would have figured out that the thing couldn't proceed before Kinder Morgan invested $1 billion in it, or maybe they could have found alternative routes or solutions, for example, sending it, you know, I don't know, down to Washington for refining. I don't know. But in any event, I think that the issue here isn't about the Impact Assessment Act being the cause of investor uncertainty today, right?
The existing toxic regulatory environment that this government has put in place. To counter yours, I disagree completely with everything you just said. In the article about Chief Cray, the Chim are one of the 43 First Nations that have mutual benefit agreements with Trans Mountain, reportedly worth more than $300 million, that offer skills training for employment, business community, or business and procurement opportunities, and improvements to local infrastructure. So you obviously think that that's a bad thing. Now, Chief Cray also likened the activist, I'm not going to call those people environmentalists because they're not. The activist attack on economic development, he likened it to the attack against the fur trade, the attack against the seal wars. And I want to read a bit of testimony here. What happens, excuse me? I would like to read to you what happens when communities' economies are cut out from under them. This is from the September 2016 Indigenous Affairs Committee, where they were looking at Indigenous suicide. And one Peter Williamson, an Inuk from the Northwest Territories, he wrote, there was what we called the seal wars at the time, when Greenpeace and other environmental activist organizations who wanted to raise money started to attack the sealing industry, which the Inuit were a part of. they really relied on seal hunting to make a living. I remember as a young person that there were lots of people in my community. And then he goes on to say about traditional lifestyles, the way you brought up, it makes a difference. We started losing that in the 1970s and 1980s too, but it started in the 1970s. Once that happened, more people did commit suicide. It was mentioned in the House today that in Alberta, suicide rates are increasing because of the strong decline in the oil and gas industry. Families are being threatened with economic disaster. Does any of this resonate with you, Ms. Johnston, or does your organization, and I read on your website you very proudly support it, you're funded by Americans, you're funded by foreigners.
Madam Chair, a point of order.
Point of order, what is it?
I would like you to make a ruling on relevance. We're here reviewing Bill C-69, and if my colleague here has a question about the relevance of what he's raising to what they're requesting be in this bill, then I would be happy.
So I'll ask.
I will be happy to answer that.
And I
am
appreciate
directly
that.
related to the testimony that Chief Cray said on his comments regarding Bill C-69. So my colleague is out of line.
So let's bring it round to what we're studying here. This is great. Carry on, please.
Well, bringing it back, this toxic regulatory process that is pancaked, that this bill is pancaked on, threatens communities, peoples, and livelihoods. I read somewhere an interesting saying, you give a person a livelihood, you give them a life. Why is it, Ms. Johnston, that you and your groups never talk about the importance of livelihoods?
1 minute.
Actually, we do. In most of the literature that I produce, I mention livelihoods. And I also mention community needs, which of course is at the heart of what we're attempting to achieve, both in terms of environmental sustainability, but then also the economic well-being of Canadians, the intra- and intergenerational equity that we're hoping that the sustainability purpose of the Act will achieve, and at the meaningful public participation provisions that we've recommended that are really designed to help get communities around the table to be a little bit more involved in decisions that directly impact them, their livelihoods. And I'll just note that it's not just about the numbers of jobs that projects affect, it's also about the plurality of jobs that projects often affect. So you have to look at not just the number of long-term permanent employment and how many workers are coming in from out of town, but also whether or not a project, for example, Site C, are going to undermine the traditional farming practices of local community members and other livelihood opportunities. So yeah, that's very important to us.
Thank you very much to all the panel members. You've given us a lot to consider as we work through this bill. I'm going to suspend the meeting and bring up the next panel. And again, thank you for your time today. I'd like everyone to take their seats, please. Okay, I don't see everybody up on all the panel members. We're missing one. Okay, we're getting there. While we're just having everyone take their seats, I did neglect to recognize two members that we have at committee that aren't normally with us, and that's MP Dave McKenzie and MP Stephanie Kuzy. I know she's been with us before, but I think this is Dave's first time with the committee, so welcome. All right, so you're welcome. It's nice to see new faces at the table. Okay, so we now have our second panel, and as I mentioned before, we do have the potential impact, well, we do have votes. The bells are going to go at about 5:30. We are in the same location, just down the hall, so I'm hoping we have the will of the committee to continue until about 10 minutes before votes, and that way we can get as much time as we can before we have to break. So we have our witnesses today. We have Stephen Hazel, with Director of Conservation with Nature Canada. Thank you for being with us. We have Jay Morrison, Chair Environment Committee, Paddle Canada. Thank you for joining us today. And we have Rod Northey, who's a partner with Gowling WLG, LLP, and he is an individual who was on the expert panel that studied the impact assessment. So I would like to turn the time over to the panel. You have 10 minutes each, and for those that weren't here when I do my little housekeeping, I don't like to cut in, but I have a yellow card when you've got a minute left in your 10 minutes. I have a red card when you've run out of time. I don't mean for you just to like drop your whatever you're saying. Just wrap it up quickly if you won't mind. Okay, and as I said before, I use the same rules for the committee members, so I try to be fair. All right, who'd like to start? All right. Sure. Please, go ahead.
Thank you, Madam Chair, members of the committee. My name is Stephen Hazel. I'm with Nature Canada. Long history with environmental assessment. I worked for the Canadian Environmental Assessment Agency when the initial regulations for SEA 1995 were developed. So a long history with environmental assessment. I wanted to say, first of all, that the current bill, Bill C-69, and I'll be focusing on the Impact Assessment Act provisions. There's a lot of good stuff there. We support the strengthening of this Impact Assessment Agency, that we support the idea that assessment should assess a project's contribution to sustainability, the incorporation of Indigenous knowledge, Canada's climate commitments. These are all good things. We support the increasing the transparency in decision, such as by requiring the minister and cabinet to provide reasons for approvals. So I wanted to focus on 5 areas in my comments. I want to talk about discretion and legal requirements. I want to talk about triggers for impact assessments under the Act. I want to talk about the project list, Federal House in Order, and regional and strategic assessments. Some of what I say will overlap a little bit with what my colleagues have said in the previous panel, but some of it I hope will be new. The first thing I want to say is that in leading up to 1992, what the primary focus of the environmental community, I think Canadians generally, was we needed rules. We needed laws. We needed to know what projects were going to be subject to a federal assessment and which ones weren't. That was a key objective. With the SEA 2012, we lost that almost completely because with very few exceptions, there are no rules, legally binding rules for what is assessed and what is not. And unfortunately, this act sort of perpetuates that problem. It creates discretion at 2 levels. No projects are assessed under the current proposed law unless they're on the project list, and we're disappointed by that. But even if they are on the project list, it doesn't mean that they're going to be assessed. They go through a whole process, the early planning process that we talked about, and at the end of that, the minister makes the decision whether or not there should or should not be an assessment. So there's discretion all the way along, which just creates uncertainty for everybody, and I would put it to you that I think it also politicizes the process, whereas under the 1995 law, proponents and stakeholders and governments knew what was going to be assessed. Under this law, we have no idea. We really don't. It will be up to at the discretion of the minister. So I think that is something that I would ask the committee to reflect on and think about ways in which we can limit that discretion, and some ways have been suggested by colleagues in the previous panel. The second thing I wanted to talk about is triggers for impact assessments. We're disappointed that the project list is the principal trigger for assessment of projects. What it means is that many federal decisions that adversely affect the natural environment will not be assessed because the project list, as it's currently written, is very narrow. We start from the position Nature Canada does, and I think we would all agree that one key function of environmental assessment is so that we have good information about environmental effects and sustainability effects so that we can make good decisions. Ultimately, it's about how can we make good decisions about projects. If the whole legal regime is focused on a handful of projects are on that list, that means we're not going to get there. The decision makers are not going to have the information that they need in order to make good decisions. We say that, I want to also note that, that in the 1995 law, they had 4 distinct triggers. There was a regulatory trigger, a disposition of land trigger, a federal proponent trigger, and a funding trigger. Now, Mr. Nordy may remind you that the expert panel in its report recommended that we continue with that 4-trigger approach from CA 1995, and it was abandoned in the 2012 law. But we say, in thinking about, okay, what projects do we really need to start getting better information about so that we can make good decision making? We say that projects, high carbon projects that we know are going to produce, megatons or hundreds of thousands of tons of GHG emissions, should be assessed under the federal act so that we can meet our Paris Climate Agreement. And there's a good example just downstream from Ottawa, upwind from Montreal, where we're not doing that. A cement plant is going to produce 1 megaton of GHG emissions every year, not including all the trucks carrying all the cement. The sulfur dioxide and nitrogen oxide emissions are in excess of US and European standards. Who did an assessment of that project? Wasn't the provincial government, wasn't the federal government, the little municipalities around Hawkesbury, right? And so their only recourse was to deny a rezoning application. And of course, the proponent, which is a European multinational corporation, of course, appealed the refusal of the rezoning to the Ontario Municipal Board. So that's where we sit. So a megaton of emissions are unaccounted for, and no intervention by either level of government to figure out how we could get those GHGs down. So we're missing the boat on that. We would say that high carbon projects have got to be on the project list at least. We think that it would be better if there was a law list like we had in the CA 1995, so that any regulatory approvals under the Fisheries Act, under the Canada Navigable Waters Act, under the Species at Risk Act would be assessed. But anyway, that would be our preference, but we think we could also do it by way of the project list. So next I want to turn to the project list itself. And I want to talk about the regulatory approach that's being taken by the Canadian Environmental Assessment Agency for listing projects under your new Impact Assessment Act. We say that it's unacceptable. According to the consultation paper, the project list would, quote, focus federal impact assessment on projects that would have the most potential for adverse environmental effects in areas of federal jurisdiction. So what they're saying is that even very bad projects with serious adverse effects in areas of federal jurisdiction may not be listed on this project list so long as there are projects that have more serious impacts. So that's a problem. That means that they only want to have a very select number of projects listed that would be subject to the whole process. I want to add that I found nothing in Bill C-69 or in the proposed act which requires the approach that appears to be taken by the agency with respect to the development of these absolutely critical recommendations. So what we would say is just delete that word most. So when instead of saying, so that the language would read that the federal impact assessments would focus on projects that have potential for adverse environmental effects in areas of jurisdiction, not the most potential. So that would be a recommendation that I would make. Next, I want to talk about the Federal House and Order. And I'll just say bluntly that the exemption of federal projects from assessment under the proposed act is just simply unacceptable. As it's written right now, federal authorities are required only to, quote, determine that the carrying out of the project is not likely to cause significant adverse environmental effects, unquote, and that factors set out in Section 84 be considered. Just trust us, is just not good enough. And let me give you an example. Parks Canada, and this comes from the Canadian Parks and Wilderness Society. I don't know if they're testifying before the committee, but they've said, yeah, go ahead and tell the story. Since the year 2012, Parks Canada has made 1,600 determinations under a provision identical to the one that I just read to you, that the Parks Canada, instead of doing an assessment, they're required to make a determination based on what we have no idea, but they're required to make a determination. They made 1,600 of those determinations over 2.5 years. Not once did they identify a project that had significant adverse effects. And these are in our national parks, where presumably we're a little bit more sensitive to what significant might mean. And remember that in national parks, the minister has got as her first priority, when considering aspects of the management of parks, the maintenance or restoration of ecological integrity. So, am I done already? Okay. I did want to say something about regional and strategic assessments.
I get it. So the problem is
just one
really,
quick thing.
really quick.
Very, very quick. The idea of having this expert committee that's in the bill, identify regional assessments, I think is a fabulous idea.
That was quick. Thank you very much. Appreciate that. Okay, who's next up? Ready?
All right. Well, I've been invited to be second, so I will take the honor. So I'm very pleased to be here. This is our third or fourth time I have been before this committee over a long time, 20 years, and I'm always honored to do this. So here I'm arriving in my personal capacity, but I am one of the four, the gang of four that wrote the expert panel report, and I will say here I'm very happy, although I'm not speaking for the other three, I'm very happy to defend any part of that report. I'm still very proud of it and happy to speak to any part of it that may assist what you're up to. The other thing I'll just say for those, I'm a bit like Stephen. We crossed paths. Stephen didn't quite illuminate how far back he goes, but the very first federal court case that ever happened to get EA in play in the late 80s was part of the machinations of Stephen Hazel for whoever he was working for or with then. So he is an esteemed member of how law came to environmental assessment. And I'm a little behind that, but I've done 2 books on federal environmental assessment, one in '94, believe it or not, on the first 20 years, and now I have a current guide. So I come at this with a great deal of interest. The final thing I want to say just on background is about the panel report. I will speak to one part of it only, but I do want to say here on the record that it's an integrated vision. And so one of the things that may make that helpful to the committee is, if you want to ask me about a specific thing, we try to balance all of the interests and the constituencies that we thought were relevant to this. The First Nation, the industry, the governments, the public, the provinces, we tried to figure out how all of them had a legitimate role. So pulling one piece out of our report is not likely to be terribly helpful, because it's not capturing all the things that we tried to balance together. Now, having said that, I am going to say one thing, and strangely enough, it echoes something I said in 1994. And I said it in '94 because it was powerful then, and that is, I believe the federal EA law needs a CRTC-like model. It needs a tribunal. Full stop. In 1994, I wrote 25 pages for this committee or its predecessor on how to do that. I'm not going to do that again here. The panel gave you a vision on why that's important. What I want to say very quickly on this topic is the thing that a tribunal can do, it spoke for itself well then as a model, because unlike a court, the facts, the experts are all relevant. Every time we go to court, we throw the facts out, the experts out, and we deal with the law. That surely is not the way to do EA, the best EA. And similarly, notwithstanding how noble and how much time our federal ministers and agencies want, they are not the same thing as an independent tribunal in how well they balance and address expertise. So that's the CRTC piece. But now you've got one more piece to this that makes, in my view, even more imperative, more vital that you do this. If you are going to have EA deal with the rights of Indigenous peoples, which you must in order to deal with UNDRIP, which you must to deal with our Constitution, and you've now embraced that, how are you going to do that without some kind of body that can adjudicate what a right is? And I believe it needs to be adjudicative, because otherwise the only place you go is court. We surely do not want to have court as the only place where you can talk about rights and get an answer. So what I say is we really need a speedier, expert-based process to adjudicate the vital question of rights. If you read the panel's report, we tried to address consent within a framework of a tribunal. The consent was not absolute, it was embedded in a framework. I cannot see a better way to do that. I'm happy to hear of an alternative, but going to court is not an alternative to that. So thank you very much for your time. I am here to try and assist. Thank you.
That was super speedy, so that made up for a little bit of run over there, so I appreciate that. Next up, please.
Yes, well, I'm happy to give up whatever of my time might be left to my two colleagues here. What I'm here to talk about is perhaps a little less relevant to you. I'd hope that maybe there would be a few members of the Transportation Committee that might drop in as guests. I don't think there are. I'm going to focus mostly on the navigable waters aspect of the bill, even though I'm a current member of the board of the Canadian Parks and Wilderness Society, and I thank Stephen for mentioning that example.
That is why we invited you to come, because we wanted to hear for that aspect.
So thank you, Madam Chair. Yes, my name is Jay Morrison, and I'm representing Paddle Canada today as the Environment Chair. I should also mention that I'm the Secretary of the Canadian Safe Boating Council. Paddle Canada welcomes the opportunity to comment on Bill C-69. We have been engaged with the right of public navigation since amendments to the Navigable Waters Protection Act were first proposed in 2009. Closely related to navigation rights is the question of safety, and so Paddle Canada has been coordinating its work with the Canadian Safe Boating Council. Paddle Canada has several recommendations with respect to the bill. The mission of Paddle Canada is to promote recreational paddling instruction, safety, and environmental awareness. Paddle Canada's 3,000 certified instructors teach over 10,000 Canadians every year in canoeing, kayaking, and stand-up paddleboard. And for the millions of recreational paddlers in Canada, we are the organization that is most concerned with their right of public navigation. The mission of the Canadian Safe Boating Council is to promote safe and responsible boating throughout Canada. The CSBC contributes to a declining mortality rate for recreational boaters, but the annual toll is still much too great, and most deaths are highly preventable. When you are boating, wear your life jacket. Allow me to do a very brief demonstration. There.
That's going to save you from the questions.
Well, I was going to say, one of the benefits
might help, though.
The benefits of it is you can see it's just webbing. It's very light. It's very breathable. There is no excuse not to wear it. And I must confess that until I had a daughter 10 years ago now, I would often not wear my life jacket if I was on warm waters that I could swim across. I'm a whitewater instructor as well, and I would always wear my life jacket in whitewater, but I didn't. These are extremely light, easy to wear them. Most people that die are not wearing their life jackets. There are a number of strengths and potential weaknesses in the proposed amendments to the NPA that are contained in Bill C-69. Our general perception is that the proposals in C-69 may, with some caveats, effectively restore an acceptable level of ministerial oversight to the right of public navigation to all navigable waters. Bill C-69 continues the use of a schedule of waters where proposed works would require ministerial permits. Ideally, and I know some of my colleagues have proposed this, abolishing the schedule would go toward restoring full oversight to all navigable waters. However, effective oversight may be realized through the bill's requirements that owners of works on unscheduled waters give notice to those that may be affected. and by providing a dispute resolution process. The caveat here is that the minister provides sufficient program resources to ensure that proponents do give such notice to all potentially affected parties, including paddlers, and that the minister does respond to unresolved disputes in a timely and effective manner. The bill should specify a time limit for the minister to respond. Whether this new approach works as intended should be closely examined when the 5-year review is done. I should add that I'm a former senior manager with the Treasury Board, and I'm very sensitive to the issue of efficiency and the cost to taxpayers. And by implementing this new regime, there is a possibility that the long waiting lists of projects and the cost to taxpayers can be reduced. And my understanding is that is why Transport Canada has proposed this new approach. Bill C-69 defines navigable water as that which, quote, is used or where there is a reasonable likelihood that it will be used by vessels, unquote. This is, in our view, sufficiently specific that it would include waters that have been, are currently, or may be used in the future by human-powered craft. Attempts in 2009 at legislating an objective canoe test, which, by the way, never was in the old NWPA, definition of navigability were, in my view, a failure. This bill's specific definition therefore represents an improvement over the old NWPA in securing the right of navigation for paddlecraft. The NWPA contained provisions that certain types of works on navigable waters, notably dams, bridges, booms, and causeways, always would require a ministerial permit, and that the Environmental Assessment Act specified that such works would require an assessment. The proposed Canadian Navigable Waters Act does not contain any specific triggers for impact assessment, and so we urge that the proposed Impact Assessment Act ensure that works that obstruct flows or change water levels require impact assessment and provision be made for assessing the cumulative effects of lesser works. Paddle Canada recommends that works that completely obstruct navigation of unscheduled waters specify a requirement that a ministerial permit be obtained. This is not a matter of only effectively maintaining the right of public navigation, but it is also a matter of safety, especially in the case of power dams and their treacherous cousins, weirs, where in the absence of safe and reasonable portages, paddlers may sometimes take dangerous risks. When asked by parliamentarians and officials at Transport Canada to name our main concerns with respect to works, our answer has been power dams. We are pleased that officials have responded positively to the need to mitigate the obvious dangers posed by power dams. However, the hazard also posed by weirs or low-head dams requires more explanation. Weirs often involve a relatively gentle drop, sometimes less than a meter, tempting the uninformed to run the weir in a canoe or kayak or even to swim in it. The drop can sometimes set up a recirculating hydraulic that can trap a boat or a person in the foaming water until they tire and drown. For this reason, those of us who are trained whitewater paddlers refer to weirs as drowning machines. As an example, a weir on the Bow River in Calgary had taken the lives of 14 people over the course of the last 30 years in many different incidents, until it was recently re-engineered. A Paddle Canada instructor, a friend of mine, actually recently recounted to me an incident at a day camp when, in spite of the efforts of a large, strong man who risked his life to attempt to rescue, a young boy drowned when trapped in an innocent-looking current below a weir. Paddle Canada recommends that no dam or weir should be permitted on any waterway without provision for a safe and reasonable portage with appropriate signage. Paddle Canada also recommends that in the case of works that completely obstruct navigation, such as dams and weirs where permits have already been granted, that Transport Canada should consider the feasibility of reviewing the status of the permit with respect to a requirement to provide a safe and reasonable means of bypassing the obstacle. Of all the rivers on the historic fur trade routes from Montreal to the Pacific and Arctic Oceans, the power dams on the Ottawa River stand out as exceptionally poor in this regard. Paddle Canada may be able to assist in identifying opportunities for improvement. Similarly, we recommend that in order to give the right of navigation full meaning, Transport Canada should also examine the general legal status of portages, particularly on historic routes. Specifically, the department should be able to advise those who travel such waterways whether they have the right to walk on private land in order to bypass natural obstacles such as rapids and waterfalls. And if not, the department should examine measures that might establish that right. Many historic portages have been lost to development over the years. One of them is within sight of these Parliament buildings. The thousands of year old First Nations portage closest to us right now was also used by every single one of the early European explorers to bypass the Chaudière Falls. These routes are a part of our shared history and must be preserved. Our final recommendation is that because the proposed Canadian Navigable Waters Act deals with an historic public right that is not established by any overarching document such as the Charter, consideration should be given by legislators to inserting a short preamble into the Canadian Navigable Waters Act that describes the nature and importance of this right as part of our Canadian heritage. Madam Chair, I would like to point out to the members of the committee that while I've been involved for a long time with environmental organizations, impact assessment is not at all my area of expertise. As a certified Paddle Canada instructor who has canoed the 8,000 kilometers from the Gulf of St. Lawrence to the Arctic Ocean, my expertise is in the safety and navigational aspects of this bill. I would be pleased to answer any of your questions. Thank you.
Thank you very much. We're going to start the questioning with Mr. Fisher.
Thank you very much, Madam Chair. Thank you very much, gentlemen, for being here. Madam Chair, if you could let me know when roughly halfway through I'm going to share my time. Because of bells, I think it's important that we all get a chance to say a few things. Jay, I'm going to go to you. I hope it's okay if I call you Jay, and I assumed you paddled here since you brought your own life jacket. I represent Dartmouth Cole Harbour in Nova Scotia. So Dartmouth is known as the City of Lakes. I was mentioning it to you earlier, and we're also on the Atlantic Ocean. So I think it's important that folks have the ability to report any issues to navigating or enjoying our beautiful lakes and our oceans. And I think that should include non-scheduled waters as well. I'm interested in your thoughts on the complaints mechanism. Is it strong enough in this bill? And maybe more importantly, is the procedure simple enough that people will be able to, the regular Canadians will be able to report an issue with regards to navigation of our waterways?
Well, again, that depends on the implementation, whether the department has the resources, whether they make it sufficiently clear to proponents that they must give notice of works to the public and how that happens, and whether the department has the resources, again, to investigate the complaints in a timely manner. That's why I put those caveats in there. I don't know to what level the Navigable Waters Program is resourced today. I know that there are fewer people than there were in 2009 when we were looking at this issue, and I appeared before a Senate committee to talk about it. Perhaps because I was a public servant, 32 years, 20 at the Treasury Board, maybe I have a little more faith in public servants' intentions to do the right thing and their ability to do so. So I think it's worth a try, but I think it needs to be monitored. And the one improvement that really should be in the bill is that the minister should have a time limit to respond to complaints.
Mr. Northey, I'm going to ask you just a quick one because I'm probably going to run out of time. Public interest. How would you strengthen this legislation to ensure that projects are truly in the public interest? How would you better define public interest? And how would you, again, change this legislation to keep it from being political?
Well, that's a great question. So the panel turned its mind to that, and our answer to that was to put the whole thing under the heading of sustainability. And so the meaning of sustainability we had is 5 pillars, and the idea was that you would balance those 5 things. And what I wanted to distinguish between the pillars of sustainability, if I might, and what we've got is the pillars were a test. You had to assess all 5 ingredients and come out with a view that overall you had something sustainable, a test. Public interest is not a test, really, because the criteria are so amorphous, one doesn't have any idea what you're balancing or what you're doing with it. So I think we've lost something in where this is headed by moving to public interest away from sustainability.
Okay, thank you.
I'd like to continue on the vein of this dispute resolution entity. The challenge, from my understanding, is having been a counsel at the CRTC. I mean, that's a model where you have a regulator that also performs a judicial function, or quasi-judicial function. But in this circumstance, I mean, would the impact assessment agency be a regulator as well as an adjudicative body, or I'm just trying to figure out exactly how it would be structured, because we've heard other witnesses suggest that it should be something entirely separate. It shouldn't be the Impact Assessment Agency. And furthermore, how would we want to ensure that Indigenous considerations would be appropriately built in and consultation appropriately achieved so that such a body would actually pass muster pursuant to UNDRIP and constitutional obligations?
Wow, that was very nicely compressed. So let me try and deal with some of that. So yes, I do hear the point, and the point is well made about the issue of how does one entity deal with these various aspects. And I don't have a simple answer for you other than I think we do have a path where you can have an entity that has a tribunal component to it, and that's the entity, the way we recommended this, that you would have some part of the agency with a board or whatever we're going to call it, with an adjudicative function over to the side, if I could call it that, as a distinctive branch that wasn't controlled by the other parts of it. That's where we tried to get to, because we are concerned about a couple of things, and you got to this. How do you get early planning? Is early planning adjudication? No, it isn't. So the adjudication and the early planning parts to this are complicated. What we wanted to do was have an independent body do an assessment, as you've pointed out, and we wanted to have some adjudicative means at the end of it all to deal with it, or in the middle of it to do dispute resolution. Now, I don't think that is problematic if a statute expressly authorizes all the different parts to it. To me, it's a balance of powers kind of problem, and you specify the roles of the various entities. So that's really the best I can say about this. I don't think they're necessarily in tension, but they need to be separated by a statutory mandate. A few other questions, but you may get back to me.
So what of the Indigenous aspect?
Well, we
oh,
are
I'm
like
done?
seconds,
Okay.
yeah, so I think I better call it quits. Mr. Sopak.
Mr. Northey, you were quite proud of the report that you and your colleagues produced, but I want to look at some testimony that we received not that long ago from Canadian Association of Petroleum Producers. CAP and the investment community today see very little in Bill 669 that will improve investment. I would say, go on to say, I would say we're at a very high risk of leakage of carbon outside of Canada, so the resource won't be produced in Canada, but will likely be produced in a jurisdiction with no carbon policy. Chris Bloomer from the Canadian Energy Pipeline Association. New projects are grinding to a halt, and we have major problems as a sector and a country accessing new markets for our energy products to the world. In short, we cannot see that timelines will improve. We expect them will be longer. Mr. Bloomer goes on to say, if the goal is to curtail oil and gas production and to have no more pipelines built, well, this legislation may have hit the mark. And then in legal review by Osler and Company, written about in Lawyers Daily, you can tell I don't have a life because I read Lawyers Daily. It was quoted by the author, there is nothing in these legislative proposals that suggest future assessments of designated projects will be in any way streamlined, more efficient, or more effective. And that's compared to your view of the legislation. Are these people all wrong?
I'm sort of puzzled how many things you wrapped together there. So what the legislation does is not with respect what the panel recommended. So it's kind of hard when you bring to me what the legislation says and critique it. I will go back to where the panel is. The panel was trying, as I was trying to say earlier, to balance off the various industry interests along with the other interests, and I thought the way we dealt with that was through an integrated timeline and by this adjudicative process, a dispute resolution process I was trying to speak to earlier. The bill doesn't do the adjudicative process, and the timelines are really, with respect, not much different than what we have under the current bill, where the timeline is ridden with timeouts. So the question we were wrestling with is how do you get a timeline that actually works?
Okay. So you're saying this, like Bill C-69, is flawed?
Well, it's yes, I would say that, yes.
Okay. Now, again, it's quite ironic that it's only the Conservative members of Parliament on this committee that talk about the health of communities and jobs and incomes. But I guess that says a lot. Mr. Hazel, in terms of SIA 2012, I live right next door to a national park, so and I'm the parks critic. opposition, so I kind of have a little bit of insight into how parks works. Are you aware that under the old SIA, they had to do an environmental assessment for a park bench? I mean, SIA 2012 gets rid of all that those insignificant assessments, freed up resources to look at real projects that had the potential to do environmental impacts. Surely you've got to agree that an environmental assessment of a park bench is not really necessary?
Sometimes an environmental assessment of a park bench is necessary. If it's adjacent to a mountain caribou path, there might be something to take a look at. But let me say that I completely agree that having 5,000 legally required assessments every year under SIA 1990, that was too many. But having a couple of dozen under SIA 2012 is too few. So I think there's a balance there that we have to strike, because we don't want to have too many legal requirements, too much. I agree with that. But could I just come back to your point about early engagement?
No,
I think it's important.
I have very little time. But just
ask the question about early engagement. The early engagement idea was intended to help industry get through projects more quickly. It was designed for them. The idea is that if we can do early engagement with communities, that we could reduce the amount of paper that's produced, identify the issues, get communities on board, get things done more quickly. That was the whole intent. And really, we all support that. If it's not working, let's figure out a way to make it work. But let's not throw that particular.
I'm not going to argue with that. Let's figure out a way to make it work for sure. Just on your park bench thing, all those small things can be developed with standards. We don't need assessments for it. Just have the right standards and implement them. I had the opportunity a few years ago to work in the oil sands. I lived at Denman Camp on the Curl project doing environmental assessment there. And again, with the effect of this legislation on energy and industrial development, and I know some on the committee are uncomfortable with this approach because it's so effective, I would point out that Andrew Weaver, the head of the Green Party in BC, just sent out a news release just about an hour ago regarding the Prime Minister's comments about the oil sands. And Mr. Weaver basically said he's disappointed that the Prime Minister quote is doubling down on a sunset industry whose expansion puts our climate targets out of reach. A singular experience for me when I lived at that Denman camp was the type of people that were in the camp. They came from all walks of life. Many were laborers who, up to that point, lived on very low incomes. These people had their education levels were low. The oil sands were a chance for them. So many were from the Maritimes. Do you, and I'm asking this of all the panel, do you agree with Mr. Weaver that the oil sands should be phased out?
You have like 2 seconds to answer that, so I think we're going to end up having to get the answer in a subsequent question.
Yes, I do agree.
Perfect.
And ultimately, there's a complete shift in global investment. Renewable energy now receives more investment than the oil and gas industry globally. There is a transition on the way, and it's going to be a tough one. And we really have to focus on just transition for workers. Absolutely.
Okay, so I just want to make sure I confirm with the committee. I did have agreement. I just want to confirm that we're going to keep going until about 10:02, and then we'll break for the vote. Okay. So next up is Ms. Duncan.
Mr. Northey, I'm so glad to hear you testify about the tribunal. I think I'm at odds with just about everybody I'm talking to who think that an agency can deliver what a tribunal can. My experience, of course, is with the energy review boards and the utility review boards in Alberta. And it's always been a tribunal. I mean, I frankly don't understand. The proposal in here is that the Impact Assessment Agency is going to adjudicate First Nation rights. I just find that absolutely astounding possibility. But without completely revamping this act, I don't know how that we can shift that. But anyway, I was really grateful to your review. I thought it was very sensible, and to me it made perfect sense based on my 40 years experience dealing with those tribunals. I would like to hear both from Mr. Northey and Mr. Hazel on the issue of substitution. I'm deeply troubled at even the concept that the federal government could defer to a provincial government to hear evidence on and rule on matters of federal jurisdiction. So I would appreciate, I can't even see any conditions that would be put on that make any sense whatsoever. On the other hand, joint tribunals have always been the suggestion to go, but many provinces push against that because they just want the feds to butt out. So I would like to hear from both of you about this issue of substitution.
You want me to go first?
Yeah, go ahead.
All right. Okay. One, I think the only example we have of trying to do it right now is in BC, and the BC legislation was modeled on the federal SIA, so there was certainly an effort in the background to that to make them work together. I would agree with you in legal terms there's some problems because federal jurisdiction, the whole nature of this is that each level of government has some things that are more exclusive, if I could put it that way, and some things are concurrent. And the problem with environment is numerous things are concurrent, but some things are exclusive. And so how do you deal with exclusive on a substitution? That's very difficult to work through. On the other hand, to take your model, I think federal-provincial cooperation is the proven path on this and should be the path that we go forward with. And in that respect, I support where this bill is, but I support where, in fact, we were with ERPGO in the 80s and SIA 92. All of them had a model favoring cooperation and not substitution. And the courts in the late 80s, when they were quite active about this, also had a fairly strong interest in seeing cooperation and not unilateralism. So that's where I would be on that.
Can I just say that I don't think substitution is a bad idea. I don't think it's a good idea. It's a bad idea, and the reason is that the federal departments and agencies, they've got decisions to make, and they've got to make decisions based on the best information that they can gather. To just hand over that authority to look at the information and figure it out to some other agency that's got different interests, different priorities, it's just a mistake. The joint review process is really the best. Sometimes we do run into problems because sometimes provinces don't necessarily want to allow the feds to come and play. But so the committee might want to think about ways in which it can, through amendments to the bill, encourage joint reviews, because that is the cooperative model. That's a better way to go. I think it ultimately results in better decisions.
Paddle Canada. I wish I could spend more time on the rivers, but I can't. I wonder if you could speak a bit to the concern that a good number of people are raising with what happened to Navigable Rivers under the Conservatives, and now also troubling. I don't think that there is anywhere in the provision the right of Canadians to recommend additions. Some have suggested that not be a list at all, and that simply all navigable waters require a review, maybe based on the significance of the proposal. Could you speak to that?
I could, and that's, to be honest with you, where I differ a little bit from some of my colleagues, especially the ones in the environmental law areas. I know Josh Ginsberg personally. We've served on the Friends of Temagami board together, but I think perhaps they're focusing a little bit too narrowly on the wording of defining navigable waters as likely to be navigated by vessels. I think that by saying that navigable waters are waters that currently are or likely to be really includes just about anything that we might want to navigate, because in my view it will include what was done in the past, whether it be by First Nations or people such as myself who are recreational paddlers.
Definition right now is inadequate?
Well, there really isn't much of a definition. There never was. There's a bit of a myth.
Well, there's a definition in the Act already.
Oh, in the bill.
Yeah.
Yes. No. As I said in my statement, yeah. I do think that is adequate to include paddlecraft, and it's more specific. In the old Navigable Waters Protection Act, there was no real definition. There was a common law definition of float a canoe. In 2009, when I appeared before the Senate committee, The department at that time was proposing a much more specific definition, i.e. 30 centimeters, but also waters that did not have a certain number of natural obstacles, dams, beaver dams, rapids, etc. in it. It really wasn't workable. I pointed out to them you only need 4 inches of water to float a canoe. I think that this definition will work.
Thank you very much. Appreciate that. Mr. Bassio.
Thank you, Chair, and thank you all for being here today. I am going to be asking a question each of Mr. Hazel and Mr. Northey. Mr. Hazel, you brought up the aspect of the 4 triggers that need to be involved in this, that the application of the IAA to just projects designated by a regulation should be expanded to include other triggers such as federal lands, funds, approvals and proponency. Why do you feel that this is so important, and also how do you feel that we can actually speed the process up and expedite it, make it more efficient?
Okay, so two questions. Why do we need a more expansive project list, or one that would actually include law list regulations? Partly because, I mean, the bottom line is that federal decisions, under what legislation they're made or wherever they are on federal lands, should be based on sustainability criteria. I mean, that's the way we have to do business in the future. And if we just decide, well, we're not going to do that, then I think we're really missing the boat and creating even more problems for our children and grandchildren. Events like we've got an Olympics. Calgary has now indicated that they want to host an Olympics in 2026. Are we not going to do an environmental assessment on that? Are we going to just let Parks Canada do what it has been doing over the past few years and just work quietly and not involve the public? I don't think we're going to get to sustainable outcomes that way. And I think the evidence is clear from the information that CPAWS had to get by access request, which again, I think that's another issue, that we're having to go to access to get information that should be publicly available. I think we really have to expand the list. I mean, yeah, so anyway, so in terms of, we need lawless provisions would be our first preference. If we're not going to go then we have to really focus on the project list. And one note I would make to the committee is that, are you not concerned that you're buying a pig in a poke here, that you're being asked to make recommendations for amendments and bring this bill forward for third reading when you have no idea what's on this project list, and the project list is really the only, it is the primary way in which projects will be assessed. Isn't that a problem? I suggest to you that it is, that you should know. You should at least have a draft list from the government.
Thank you, Mr. Hazel. Mr. Northey, on the expert panel you talked about the position of why life cycle regulators should not lead or chair or beyond the IAA, a part of the agency. Could you explain, the importance of that as to why they should not be in that position, and why that recommendation was made?
I'd like to think we were not quite as absolute as they shouldn't have any role. I think what we were really concerned about was the idea that some 2 of the 3 legs to environmental assessment right now were largely industry regulators, and were, at least in the case of the National Energy Board, in some public controversy over how well or how independently they were of the industry they were regulating. So what we were trying to do was disentangle the impact assessment component of their mandates from their regulatory components. And so we were pretty blunt about having an agency lead IA, but I'm not troubled by the idea they work together with those regulators. What we're trying to do, though, is speak to the point of, you've got to have some independence to do IA that isn't simply covered by the industry mandate, if I could put it that way. So that's what we're wrestling with.
I'd like to expand and finish off. I've got a little bit of time left. Where Mr. Amos was going, once again, I was involved in an environmental review tribunal process in Ontario, and so I understand the environmental assessment and tribunal process, and think that it was a good process that we went through in Ontario. Would you see that as a good addition to this bill to bring forward an environmental review tribunal as an appeal process?
I think I answered that one in my first. Absolutely. I think that is exactly what we need. The only thing I would say that the Environmental Review Tribunal might be inappropriately focused on environment relative to what we're speaking of here, because, as I said earlier, I think one of the most compelling things that needs to be addressed is Indigenous rights. But I would also like to say one of the things that's not in the Environmental Review Tribunal mandate that the panel was very interested, and I want to emphasize in light of the industry concern here, is what is the timeline? How do we make sure that regulators, if independent, are responsive and to timelines? Ontario's not had a good past in its environmental hearing processes of really mandating, controlling timelines. So I would want to make sure we didn't go down to that path here if I were to support your recommendation.
I think Mr. Hazel wanted to make a comment on that as well earlier.
Well, I would just say that there has been a lot of support for this idea of having a tribunal, doing actual environmental assessments, as Rod was saying. I just want to make sure that it's clear that idea, that the CRTC-like body, the tribunal, is different from what others have been talking about, and that is the right of appeal, the appeal of decisions to, so you'd have a decision made at the political level, subject to some sort of appeal, or perhaps a kind of a revved up judicial review process. So those are two separate things. I think we need to be careful about that.
I have to be very careful with the time because we're trying to get one more questioner in before we have to leave for votes. Go ahead, Ms. Guzzi.
Merci, Madame Présidente.
Thank you, Madam Chair.
Pride ourselves on the steps taken to protect the environment when acquiring our natural resources. And the information that I'm about to share is from some key facts from the Government of Canada as recently as July 2017. So, for example, point 1, per barrel greenhouse gas emissions have decreased as a result of technological advancements in the oil sands. They've helped to create more energy efficient practices and to decrease GHG emissions in the oil sands. And one of the most important mechanisms used to achieve this is cogeneration, which of course is a process where steam and electricity is produced simultaneously. And by converting energy and byproduct into electricity that would otherwise be waste, cogeneration has contributed significantly to the 30% decrease in per barrel GHG emissions seen in the oil sands since 1990. In addition, most GHG emissions, it would seem, come from our cars. And while GHGs are emitted in the extraction phase of the crude oil production process, most of the life cycle emissions of fuel actually come from vehicles' tailpipes. And final combustion of gasoline emerging from your tailpipe accounts for approximately 70 to 80% of well-to-wheel life cycle emissions. With these vehicle emissions are the same regardless of the crude oil from which the gasoline is derived, of course. The third point would be that, specifically relevant to the oil sands, tailing ponds technology is improving significantly. Oil strand extraction results in the accumulation of large amounts of residual waste, known as tailings, of course, which contain a mixture of water, clay, unrecovered bitumen, and solvent, and dissolved chemicals, including some organic compounds that are toxic. These tailings are stored in large ponds, of course, similar to water dams. The water released from these ponds can be recycled and reused in oil sands processing. However, the majority remains as mud. Almost definitely.
Can we just get some relevancy?
It's certainly relevant, Madam
Tied
Chair.
to the bill.
I'm hoping that we can get it back to that.
So all oil sands land, of course, must be reclaimed. The Government of Alberta requires that companies remediate and reclaim 100% of the land after the oil sands have been extracted. And of course, reclamation means that the land is returned to a self-sustaining ecosystem with local vegetation and wildlife, which of course, as Albertan, I'm very proud of this as well. In the oil sands area, the Government of Alberta has committed to conserving and protecting more than 2 million hectares of habitat for native species as part of the 2012-2022 Lower Athabasca Regional Plan. And in addition, there are almost 4.5 million hectares of federally protected land just north of the oil sands, so a significant amount. Point number 5, oil sand water withdrawals are very closely monitored, of course. The Athabasca River Water Management Framework ensures annual withdrawals by oil sand companies never exceeds 3% of the Athabasca River flow. And in practice, annual withdrawals are often less
Ms.
than 1%.
Kuzy, can you just bring it round to the bill that we're studying?
There, Madam
Thank
Chair.
you.
Thank you so much. Certainly it's relevant. I mean, this is specifically relevant to both the environment and the oil sector, which I believe is the two cruxes of Bill C-69. So I think it's all very relevant indeed. So where was I? Oh yes, in practice, annual withdrawals are often less than 1%. The framework also limits, monitors, and adjusts withdrawals from the river on a weekly basis. Finally, point number 6, almost all water in the oil sands is, of course, recycled. So most water used in oil sands development is actually recycled. 80%, in fact. 80% for established mining operations and approximately 94% for in situ recovery. However, some new water is required and comes from a variety of sources, including on-site drainage, collected precipitation, rain and meltwater, underground saltwater, brackish, I've always liked that word, brackish, aquifers, and local watersheds such as rivers. So I would say, given these incredible improvements that have been made and have been recorded by the Government of Canada, most recent, as I said, is July 2017, if Mr. Hazel can still, in fact, agree with Andrew Weaver's comments earlier today that this should concern all Canadians who took the Prime Minister at his word when he said he would build a clean, forward-looking economy. That means providing targeted incentives and support programs for industries who are embracing low-carbon solutions. Instead, the Prime Minister is doubling down on a sunset industry whose expansion puts our climate targets out of reach. We need to be investing in our shared future, not subsidizing the wealth of Texas oil companies. Mr. Hazel, are you still in agreement with the comments of Mr. Weaver, given the information that I shared with you in regards to the incredible environmental improvements which have been made in regards to oil sand developments? Thank you.
We got 1 minute for the answer.
Okay, so I would say, congratulations to the oil sands industry for reducing their per barrel emissions, but the reality is that the emissions in the oil sands industry and greenhouse gases continue to increase, and it's the largest growing source of GHG emissions in the country. It can't go on. The oil sands industry, it is a sunset industry. We've got to figure out other ways of doing it. We have to decarbonize the economy. That's going to be tough, and it's going to be tough in Alberta, but we've got to figure out a way.
You got 20 seconds?
Yeah, certainly. Well, I mean, certainly, I certainly value the different petroleum products that exist. Clothing, I see we're wearing it, contacts and glasses, helmets, exactly, hand lotions, ink dyes, antifreeze, perfumes, nail polish, soap, detergents, medications like aspirin, water pipes, glasses and contact lenses, as I mentioned previously, pillows, dishes, which we're eating off of, phones, golf balls, ammonia cameras, and heart valves.
Thank you very much for that exhaustive list. I also want to thank our guests today. You've given us a lot to consider. We were able to drill down on some very specific recommendations, very helpful. Thank you, and I will now end the session. The reason I'm ending it is we have votes. There's no point in you waiting, so we'll end. Thank you.